Good morning, Minister of Justice, distinguished speakers, organizers, and the guests. I'm now wearing the hat of the chairman of the board of Riga Graduate School of Law. My name is Inga Kaczewska, and I'm very happy to welcome you all to this first, I guess, Riga Artificial Intelligence Day. I'm not artificial yet. Neither also the team that actually organized this this day. And I have heard that they met in live and they had a conversation, and they thought that it's a good idea to organize such a day discussing artificial intelligence and interaction with business and the law. So when great human minds meet, great ideas follow. And we see from today's agenda that actually the 5 universities and their faculties have made fantastic program, fantastic agenda, and a lot of questions will be raised to discuss. And that means, and I want to thank those great human minds that actually created this program and have made this day happen. So thank you very much. And we see that also there is great interest of participants and of guests to this event. That also shows that, that this event is needed. And I thank also all the participants that are here and watching us online for their interest and engagement. And also thank Minister of Justice for coming, also showing interest and engagement. So indeed, artificial intelligence impacts our lives and our work. And very many organizations, universities, governmental or institutions, courts, as we will hear, are using, developing, testing artificial intelligence. And artificial intelligence is making significant contribution to global GDP and business value. And where there is a business value, where there is economical interest, there's also always questions about the law, legal framework, and ethics. And my concern is that artificial intelligence is actually developing faster than the legal framework, even if it's soft legal framework. So it still cannot go so fast as artificial intelligence. From my perspective, wearing another hat as associate professor, as we prepare also for the new academic year, I see how the artificial intelligence impacts the teaching and learning. And there are, of course, a lot of positive things as regarding the teaching and learning in universities and using the artificial intelligence. And there is a really funny, maybe for me, funny story that this spring at the graduation of Riga Graduate School of Law, the students that were addressing their classmates, they actually didn't thank the professors or parents first, but they thank ChatGPT because it allowed them to graduate. So so it's very challenging as well. So wearing another hat, so I have many of those, being a practitioner in international arbitration, I read just a few days ago in the Conflicts of Law Net the article about artificial intelligence in arbitration. And this article raised the critical question, can non-compliance with the EU Artificial Intelligence Act serve as a basis for courts in EU member states to refuse recognition and enforcement of arbitral award on procedural or public policy grounds? For example, if the arbitral award is made in the United States and it should be recognized and enforced in Europe, but in the United States they use the artificial intelligence, what is not in compliance with this EU Act. So whether that will be a possibility to challenge this recognition and enforcement. So there are a lot of challenges, and there are also like dark sides of artificial intelligence. So first is like, are we losing our critical thinking, or what about privacy, security, misinformation, etc., etc. So therefore, I'm very happy that today many of those questions, or a few of those questions, will be discussed among those very distinguished speakers, and I really would like to encourage you to get involved and ask the questions because it's really influenced our life and our work. And of course, at the end, I have to say that I'm very happy that Riga Graduate School of Law is a host of this event. We are always for the progress. We are modern, and we are for the interdisciplinary way of looking at the things. So I wish you a productive day and great discussion. Thank you very much. Now I would like to invite, and it's my really pleasure to invite, distinguished Minister of Justice, Madame Libiņa Egner, please.
Good morning, distinguished guests, colleagues, friends. I'm really privileged to stand here before you, and I really also want to thank Riga Graduate School of Law, Riga Technical University Business School, and all the partners who organized the conference from Munich, from Hamburg, Stockholm, especially Dana Beltman Carlsons, and all the others. This collaboration here in this conference, it shows that artificial intelligence cannot be understood through a single discipline. And it touches law, technologies, businesses, and it also depends on our liability to work across the boundaries. And by working together, we recognize that also sensible regulation requires us to understand the technologies we govern, and responsible innovation depends on respect for the principles and values that protects our society. Artificial intelligence is no longer a distant dream. It's here, and it already shapes how we live, how we work, and even how we think. And also, Latvian justice system, we use AI anonymization tools to publish court decisions, protecting privacy while making justice more transparent. Also, this openness encourages developers to build better tools and our judges and lawyers to have better working environment. And we are also testing other kind of AI that we could use. For example, we are testing speech-to-text software to help court reporters. In parallel, also our ministry continues to digitize the justice system as such. As you know, since 2021, the e-case system has put case files online and allows digital fillings, and video conferencing now lets people attend court from anywhere. And we provide also kiosks for those who do not have the necessary equipment. Courtrooms are equipped with audiovisual technology, usage is growing rapidly, and these systems nowadays support us but do not replace human judgment. We train judges, we train legal professionals to ensure that technology respects rights and judicial independence. We are using AI models to create detailed three-dimensional maps of our land registry. This is one of other mandates the Ministry of Justice here in Latvia has. And to harness these technologies, we must understand them, we must know them. Only then we can see the opportunities they create for Latvia and build the expertise or our decisions makers need. So this conference, it also asks us, should we consider the role of intellectual property right now? And we even have heard that there are also people who would say, delete all IP law. arguing that patents, copyright, and other IP issues, they hold back the innovation. But we lawyers, we really know that patents, copyrights, trademarks, they let inventors and artists receive recognition, but also receive their financial benefits. They make ideas public, so they offer the possibility to build on them, and also patent law encourages disclosure, copyright rewards creative expression, trademarks protect consumers, and trade secrets safeguard know-how. So this balanced system in today's world, it should be protected in a way that we also don't really lose the track. And while adapting to new forms of innovation and ensuring that AI tools serve as assistants rather than masters, and that human judgments remain in control. The EU AI Act, you will discuss a lot it today. It aims to protect creativity and privacy while promoting innovation. And preparing for it means training our people, building risk management frameworks, and setting up the partnerships that will help Latvia comply and thrive. We all see, not only the politicians, also the businesses and the academics, we see that we could build up our country and lead by example. We are following the AI's Act's approach. We can protect our citizens' rights and open new markets for Latvian developers, engineers, and designers. And we also know that the Act is a part of a broader European strategy that includes innovation packages, AI factories, and coordinated investment. And we should use these programs to build up AI skills, attract private investment, and join European partnerships. Our universities should become centers of excellence, and our startups can create products that meet Europe's standards and also have this human approach, human-centric approach, and not only comply with regulation, but also earn trust at home and also abroad. So we all know artificial intelligence will not wait for us. It's there, and it will reshape justice. It will reshape, and it's already reshaping commerce and society, whether we will participate, we want to participate or not. And our choice for each of us, it's to shape this transformation, or to shape this transformation as we would like to have it, or we will be shaped by it. And I think we all choose the first option, that we are those policymakers, that we are those creators, that we are those lawyers who are shaping the transformation. We understand all the risks, but we see a lot of potential. And I think also this conference is giving us the possibility to look at the potentials with open eyes on sunny sky. This summer we don't have it every day, we all know that. So I really wish you all a really great Riga AI Day. Thank you again for giving me the honor to open this conference, but I really trust that this conference will be one of the starting points that we have this conversation even further. Thank you so much and have a great day.
Good morning, distinguished guests, dear Minister, dear Inga, current director of the Riga Graduate School of Law. And so my name is Claudio Rivera. Today I have two hats in a way. One is welcome you from Riga Business School, and the other one is to be a moderator as well for the event. And it's really an honor that we have this event. Professor Dana, Professor Dana Beldingman came to my office. It was end of the last year with this proposal, and really it was a very a great idea to actually start discussing, and it is in a way the result of 1 year of conversation and dialogue. And I hope this is the first of many events that we can have together between the Riga Graduate School of Law and the Riga Business School. Now we are in two parts of the city because Riga Business School just moved to Chipsala, right? So we are now within our mother university, the Riga Technical University. So we now cover the whole city together, right? And so the artificial intelligence, the minister properly has said, is a transformative technology that is changing already how we do business, how we change the way how we educate, how the process of societies are happening. And my colleagues and I, coming from the business school, so what are our priorities is to try to understand how our businesses can be prepared for the future, right? And this is what, as a moderator today, a little bit is my objective, my personal objective, is that we walk out from here with some of the key question and dilemma we need to be observing. You know, speaking in AI terms, not to get the right and definitive answers, but to have the right prompts to after go and look for those answers as we move forward, right? And so this is the objective for today. And we have, you know, a multiplicity of regulations in the world today. So United States is taking one specific path. China is taking another specific path, maybe quite similar to the United States, much more decentralized. Europe is taking a more centralized approach to artificial intelligence with the European Union Act. One of the things we are going to be discussing during the whole day is the famous Brussels effect, and whether the Brussels effect also will happen with artificial intelligence. Now, this is a big question as we move forward. But also as a business school, what we try to understand is how we can help our businesses, especially the small businesses, the SMEs, to start getting ready to adapt their business models as we move forward. A couple of years ago, I believe it's two, there was a Nobel Prize given to professors from the United States and the UK, and they published a book called Why Nations Fail. It's a book I highly recommend to read. And in how they start their whole discussion and debate is that one of the reasons why United States has been so successful on a thriving market economy was that from the very beginning they started protecting individual rights on their personal innovation. So the protection of what we create was a cornerstone of how the American innovation and market economy and meritocracy, that is a core value of a US economy, has been built. Today, this is what we are going to discuss. Is actually artificial intelligence at this moment challenging the very cornerstone of innovation, of individual rights to our own innovation? Why copyrights exist? Why intellectual property rights exist? For two reasons. One is to protect what we create, but the other reason is very important, is that innovation continues. Who wants to create something that nobody can use afterwards? There is no reason for an innovation not to be used. So any intellectual property right is not a right to a very specific creation, but is to the expression of the creation, but the idea can actually continue to be used in the future. So today we are going to try to debate on all this, and we are going to try also to understand how in Latvia, we can start helping the business community on this sense. And for that, we have a very distinguished first panel, and also we have a very distinguished second panel. But I will start introducing first the first panel. And first, I will give you a little bit of details on how the plan will go. First, we will have Professor Dr. Matthias Leisner with a presentation on, and it will last around 40 minutes. And then we will have Professor Lucy Antoine, and then Professor Dana Belniman. And then we will have a Q&A session. And then in the afternoon, so we will have more the business practitioners and consultants part. So we will have more the legal part in the morning session and more the business part in the afternoon session. A couple of very practical things that I think are important. The number one is there will be a coffee break with refreshments at 12, and that is going to be in the first floor, and that is mandatory to go there. So because that's what I think these events are also part of, so is to network. The second one is that we are at this moment broadcasting this event live in YouTube, but after the event we will unpublish the recording. So, and the reason is we want to protect our conversations, right? So there will be, we want our presenters, our speakers, to actually be very open and direct and speaks. And these regulations are on the making, and the enforcement of the regulation on the making. And so we want them to be very open and frank. And we also would like your questions to be very open. It doesn't mean we will not publish it after in some way or format. So that's something that we will discuss it in the team right after. Okay? So, without further ado, I will invite first Professor Matthias Leisner to the stage. Matthias Leisner is Professor of Private Law and Intellectual Property Law at Ludwig Maximilian University, Munich. He studied law in Berlin, Brussels, Munich, and Cambridge. Matthias was the head of the Commonwealth units at the Max Planck Institute for Intellectual Property and Competition Law in Munich. From 2007 to 2016, he was professor of civil law, intellectual property law, and competition law, and director of the Institute of Commercial and Economic Law at the University of Bonn. His specialties are intellectual property law, unfair competition, internet law, and data law. He has published 7 books and more than 200 articles in these fields, and has been consulting on IP matters by various government departments and non-governmental organizations, as well as international institutions such as the European Union Parliament and others. Professor Leisner, the floor is yours.
Thanks very much. Thank you very much, Claudio, for that very kind introduction. Madam Minister of Justice, Magnificenz, as we say in German, Inga, Dana, it is a pleasure to be here, and I'm very happy that we have put this together. You might ask me the question, why here and why now? And I think there is 2 elements to that question. The first element relates to a story that happened to me yesterday. For being here, I rented a car, and arriving at Riga airport rather late-ish, like 11 p.m., I was a little bit concerned whether it would be easy to get that car. But then the Hertz robot greeted me and said, like, please put your driving license in here, please do this, please do that, and in a fully automated procedure, I got my car keys, being helped by an individual person, but we had a very funny discussion on whether we would need him in the future anymore. And why is that the first element why I am here? Well, that is partly because the perception of your countries in Germany and in some of the other larger countries of the European Union is very much that you are at the forefront of technological developments in the area of fintechs, in the area of AI, and in particular in the area of the digitization of the public administration and the judiciary system. So it is our interest to learn more about the economical side of that development, about the SMEs developing here, about the business models developing here, and so forth. That is the economic part of that story. The second element is a policy part of that story, because of course it is of particular interest what policy needs go along with that kind of economical advancement. So what policy needs a smaller member state has for those kinds of SMEs and whatnot. Those might not be the same policy needs we have. There might be an additional need for flexibilization. There might be an additional need for deregulation. There might be a need for flexibility we have to cater to. And it is a particular interest of mine to learn more about that. And whereas we will cover regulation and the AI Act in Lucy Anton's presentation, which will follow my presentation, I will focus on intellectual property rights. And actually, it's always good to have a quotation the Minister of Justice also had. And Jack Dorsey, the former president of Twitter, today infamously renamed as X, just tweeted that we should probably delete all IP law. And Elon Musk didn't wait for very long to fully agree that IP law should be deleted. I respectfully disagree. I do this for about 30 years now, and even within those 30 years, I have heard a couple of times, perhaps 3 times, about the beautiful deaths of IP law. Actually, it has never died. It's alive and kicking, and even many of those models we will discuss here, such as open innovation, collaborative innovation, user innovation, are still very much based on proprietary rights. It's just about dealing with those proprietary rights on the basis of licensing agreements, networks of contractual agreements, and the like, but none of that has led to the end, delete, death of IP law. Rather, IP law has gotten more and more complex, but it hasn't died, and actually I'm quite sure it won't die. But coming closer to to the topic of my presentation, the intellectual property rights, and in particular copyright, there is of course a lot of specific disagreement as well, because what's behind this is that there shouldn't be property rights, that all this should be totally free, and of course many authors, many composers, many artists disagree. They talk of a big steal, a big theft and whatnot that is equally overheated probably, but I tend to agree with Tobias Holzmüller's quote, the CEO of Germany's and Europe's largest music collecting society, GEMA, in the field of copyright law in musical compositions, and he talks of the AI as a new social question, discusses a lot of whether there should be fair remuneration for the artists, for the composers in the fields, and basically concludes a recent op-ed with a sentence, perhaps this simple rule can serve as a guidepost. If AI output competes with works created by human artists, the human authors should be remunerated as if their works had been directly used. Now, I respectfully disagree as well. If it was about the same kind of remuneration, if the AI in a highly transformative way has created new content, then I think we would forego some of the possible efficiencies we are watching in the field. I think the truth is somewhere in between those two quotes. Delete all IP law on the one hand, and have the artist remunerated as if there was no IP on the other. The truth will be somewhere in between. It will be in fairly remunerating without prohibiting. It will be in some kind of collective licensing for at least high quality training data. And actually my presentation today is a lot about how different countries worldwide and how different economic regions worldwide deal with this kind of challenges. And for that, I will first give a brief view beyond copyright to paint the larger picture, what we will discuss today, including regulations such as the AI Act and all those other acts the EU has recently enacted in the last couple of years. I will then discuss specifically copyright law and the question to what extent AI training infringes copyrights and what kind of exceptions are in place and what the discussion is worldwide. And the juries are still very much out in a worldwide scale. They are in the US, they are in Asia. Claudio mentioned China. Japan is also very interesting with a very liberal attitude towards AI, similarly in Singapore. And I will then discuss the output side, whether AI-generated material, those infamous hallucinations, might or might not infringe copyright law, and then concluding against that very multifaceted, very diverse background of a comparative law overview worldwide, I will briefly discuss possible roads ahead. But let me start first by painting the larger picture, and that isn't just about copyright law. It is, of course, also about personal data protection. It's about the protection of personality rights, such as the right to privacy. And those rights, personal data, the right to privacy, go way beyond copyright law. They might also, for example, protect a certain style, the voice of an artist, a way to play a musical instrument. All that might be protected by the GDPR. All those are personality elements, all those are personal data, and the general rules of the GDPR apply to that kind of data. Accordingly, for example, in 2024, the Irish Data Protection Commission injuncted Meta for its AI training and basically prevented Meta from training on the feeds they have. And make no mistake, the Federal Trade Commission in the US was equally skeptical with regards to US citizens' right, having presented their material on Meta and Meta just training on that material without asking their users. So GDPR rights, personal data rights, might also require contractual authorization of training. Trademark rights might come into play if, for example, certain businesses, certain artists are crowded out of searches, out of internet searches, are no longer visible because those searches are flooded with AI-based material. Unfair competition law might come into play with regards to certain transparency requirements. And for example, the new AI Act, in one of the elements that I think really deserve agreement, provides for all those kinds of new transparency rules. If you used an AI, you will have to make clear that you used an AI. If an AI system is producing content, that content will need to be tagged as an AI-based content. So complemented with unfair competition, transparency will be a major issue with regard to AI technology. So what is the European Union's answer to all those kinds of challenges? The European Union's answer in the last couple of years has been a flurry of regulatory activity with a large number of acts being enacted, which now will have to be specified and implemented. And the centerpiece of that legislation, of course, is the AI Act of 2024. Lucy will talk further about that. It's basically a product safety kind of regulation with a risk-based regulation approach. And I think the documentation and transparency provisions in the Act are really important, and they are good news. All the legislations worldwide try to address those challenges, and again, make no mistake when we are now told that we are over-regulating and whatnot. For example, addressing deepfakes is a huge challenge, not just for the EU. If the US doesn't have regulation on the federal level, it doesn't mean that it doesn't have regulation. There is about 40 states of the US which either already have or are contemplating deepfake regulation. So in the US, the picture is also very complicated. It isn't just about a very liberal attitude, a very let's just do this attitude. They're doing the same thing. They're just not doing it on the federal level because at the moment it's very hard to legislate on the federal level in the US. They're doing it on the state level. So transparency and documentation duties probably are good news. And in the AI Act, this concerns both levels. Downstream, transparency duties relating to AI output, informing the consumers and the users that a certain content was generated by AI, but also upstream transparency about the origins and quality of the training data, with all those security-related elements to it, because it might be very important to know about the quality of the data, the metadata, whether it was in compliance with, for example, legislation to protect young people, to protect children and whatnot. But it's also important with relation to EU copyright law, because their training data might have been based on copyrighted content, and then you need to know whether licenses were in place, whether all this was taking place legally, and we will talk about that further in our event this morning. What's important about the AI Act, though, is that it contains many, many open-ended provisions and rather general standards, and that those standards will now need to be specified and applied in practice. And that is one of the take-home messages of a general nature of my presentation today, that I'm firmly of the opinion that with all those acts now in place, and there is a broad package of platform and digital related regulation, as you all know, the firm focus for the next couple of years in the EU should rather be on the specification and effective application of those acts than about any new regulation. I would even talk about a need for a regulatory break on the EU level at the moment. We should rather focus on the specification and effective application of those acts than having any new regulation and add layer and layer of complex regulation upon that multi-layered regulation. And that is also because there is a lot of consolidation discussion in Brussels now. Many of those acts aren't very well coordinated with each other. There is certain inner contradictions, there is certain overlaps. So what we need to have is a consolidation discussion. We have to discuss how those acts should smoothly work and interact with each other. And that is why I think the discussion should be on the specification and the application of those acts for the next couple of years, instead of laying further layers, instead of adding further layers of regulation to that established system. And as you all know, as parts of that system, we have to discuss about the Digital Markets Act, very much relating to big tech, about the Digital Services Act relating to the digital platforms, the Data Act relating to commercial business data, and Industry 4.0 data. And of course, Brussels, indeed, in the wake of the GDPR, is hoping for a Brussels effect, Europe as a frontrunner of global regulation. And although I think there will be an opportunity for this, as I said, all the legislations worldwide are challenged with similar challenges in the field. I think for large parts of that package, no Brussels effect can realistically be expected. It's just that the worldwide policy discussion has changed a little bit. Legislations are more focusing on innovation. They are less focusing on regulation, actually. And to be honest, to speak completely open here, I am also a little bit concerned, because while we are seeing and perceiving that regulatory Brussels whirlwind with about 500 pages of digital-related regulation in the last couple of years alone. Think about the Magna Carta, that was 10 pages. Think about the German Civil Act, that's about 500 pages. And now we have 500 pages of regulation relating to digital business models, to platforms and whatnot. And at the same time, with regard to the large base fundamental models in generative AI, we have about, that's numbers from 2022, we have about 73% coming from the US, 15% coming from China, and then less than 10%, and that's the EU and all other countries worldwide. So the EU is no longer a single player in that anymore. It's the EU and all other countries worldwide. That might give us reason for concern. I think we might have a strong suit in specifying those models, in applying those models, but we don't have those base large language models in the EU. And we don't have the large cloud service providers either, at least not at the moment. And the question from my point of view is whether this entire regulation package, which will really foster competition, or whether it might mainly hit the EU SMEs. And that is, of course, a very much open question. The EU is very aware of that challenge, and what they try to do is extend the impact of that regulation extraterritorially based on the market effects principle. If you put certain business models on the European market, then the EU regulation will apply extraterritorially, even back in the value chain, right? Even with regard to your production, your training activities, EU regulation will extend in an extraterritorial way, and Lucy will talk a lot about this. But the problem here is still in enforcing that regulation globally. It will still be easier to enforce it against European SMEs. You have jurisdiction, you have them in place in Europe. It will just be hard to enforce that regulatory package against US companies, against Chinese companies. And I think we have to be very concerned whether this, in the end of the day, rather hits small European SMEs, and whether big tech will negotiate all this away, will litigate this away, and in the end of the day effectively not be as much hit by this as the European companies. And here my major concern is about competitivity and about competition, because the only answer to big tech will be European competition. And that is why we need a lot of flexibility in enforcing this, and a lot of, I would say, leniency in enforcing this also, in order to make it work for small and medium-sized enterprises in the EU. And there is a lot of flexibility in the framework. There is a lot of exceptions for SMEs in the framework, and I think we will have to make those work. That was a kind of general introduction to my keynote, and I'll come back to this in the very end of my talk. But let's now focus a little bit on copyright law, because that's my specialization, and that is what I would like to talk about with you today. And we will have to cover some technicalities as well. We'll get a little bit more complicated, but you will see we are all fighting with those challenges worldwide, and we are not on so bad grounds in the EU. I think in the EU we have a very attractive offer in that regard. The common ground worldwide is that AI training, both of the base models as well as of more specific trained systems, requires reproductions of copyright works. No matter whether it's about the base models or about further specifications in the legal field and specific business field, we need training data, we need high quality training data, and that high quality training data will comprise copyrighted works, and AI training for technological reasons requires reproductions of those works. Those reproductions under EU copyright law will be covered by Article 2 of the InfoSoc Directive, so what we need is an exception to copyright law to justify copyright training. And indeed, we have those exceptions in place. Already since 2019, with the European Directive on Copyright in the Digital Single Market, we have regulated the field in the statute. The Americans haven't done this because they have fair use, but fair use doesn't provide legal certainty either. We'll discuss this in a minute. In Europe, we have two new provisions on that, and this is first, Article 3 of the DSM Directive for non-commercial text and data mining and training, and Article 4 DSM Directive for commercial text and data mining and training. And the concept of text and data mining under those provisions, although there is some discussion here and although there might be an ECJ judgment needed in the end of the day to clarify this, those provisions from my point of view and from the point of view of the overwhelming academic discussion in the EU cover AI training. So Article 3 and 4 DSM Directive are the provisions Europe has provided to deal with AI training. How do they work? They first require a lawfully accessible work. So don't go behind paywalls. Don't just copy from illegal shadow databases in the internet. But again, the Americans are more liberal here. In one of the most recent cases, Bartz and Anthropic and Kadri, the most recent cases from the US on AI training, one of the courts also said, if you use illegal material from the internet for this, if you just take a digital database because that was cheaper, easier, move fast and break things, then you have broken things and you will have acted illegally. This isn't fair use. You need lawfully accessible material. So if you want to go behind the paywalls for your training activities, you need to pay. There must be lawful access. The storage of the training material under the EU exception rule must be limited in time as long as necessary for the purposes of the text and data mining for the AI training. Now that is bad news technically, because for sustainable training, for effective training, for having efficiencies, of course you need to store those training databases. But there is some flexibility here. You might store it as long as necessary for the purposes of the text and data mining. I think in the end of the day, in the court's practice, we might be able to work with that. We might be able to flexibilize it. It's about what I said. We have to apply it. We have to make it work. So it might be extended to cover what we need. And then most importantly, whereas non-commercial training then is entirely free. For commercial training, there is a possibility for the right holders. That is on the one hand, the major companies, the big entertainment companies in both the movie industry, the musical industry, they can opt out from that exception if the training is done for commercial purposes. So that means if they, in a machine-readable way, take their contents, no AI training with those contents, then such machine-readable opt-out will make the exception to copyright law non-applicable, and the AI training will be illegal. You will need a license. In this case, you will need a license. And that is a very intriguing provision because the question is very much on whom is the onus to make that machine-readable opt-out work. It's very hard to establish this technically because the opt-out would have to wander with the contents, right? It would have to accompany the contents, and it's very hard to achieve. So who is responsible for making it machine-readable? Is it the rights owners? Is it the tech companies who have to make sure that they understand those opt-outs? A lot will depend on the specification on this, on the application of this. And again, make no mistake, other jurisdictions aren't so much more liberal. The UK just recently is considering similar plans, an opt-out based system, and they are even considering an opt-out register by the public administration in the UK in which right holders could enter their opt-outs, and then the tech companies would have to look into that register, whereas whether they are training on legal material. So a lot will depend on how to apply this. And a lot of issues are unsolved. Does it work presently? I would say it hardly works presently. We don't have a real opt-out standard. The EU AI Office, meanwhile, has published practice guidelines. And in those practice guidelines, they focus on the robots text file, like with for internet scraping. But there is a thicket of possible alternatives. So we have a lot of different possibilities in the field. And for the moment being, the practice guidance is just focusing on robots text. That is probably good news for the tech companies, because if the tech companies just take robots text into account, which they do with their crawling technologies anyway, they will be in compliance with that practice guidance. And so on a worldwide scale, on a global scale, it will be okay to comply with that practice guidance. Then you can argue that you have a policy in place that is in line with Article 4 DSM directive, that with your training you were acting legally under that regulation, and copyright won't be so much of a problem if you are outside of the EU, because then EU copyright won't apply to your training procedures. But what about the copyright side to this, the copyright law side to this? What about the European companies? Because they have to comply not just with that extraterritorial regulation, they also have to comply with copyright law proper. And in that regard, the story gets more complicated. We have a couple of cases meanwhile. We have one case from the Hamburg Regional Court, which is on appeal before the Hamburg Court of Appeals. And in that case, the Hamburg Regional Court on copyright law proper, on European Union copyright law, not the regulation in the AI Act, where you comply with that practice guidance and everything is fine. The Regional Court of Hamburg said, well, machine-readable opt-outs, that also means opt-outs in natural language. Because meanwhile, the machines, the large models, can of course read natural languages as well. And so you have to understand the standard terms of use for a website. You will have to analyze this. And if you don't comply with those standard terms of use, it won't be possible for you to train. Now, if that judgment was applicable, then this would mean that suddenly a delta opens up between inner European training and specification of the models and training and specification of models and systems outside the EU. Why would that be the case? Because to comply with the AI Act's regulation, have a policy in place to comply with EU copyright law. And that is a kind of regulation that applies extraterritorially. You would be able to argue that you are in compliance with the practice guidance of the AI Office. You would argue that you are taking into account the robots' text files, which everyone in the business does, and then you would be perfectly legal. Training outside the EU. Training inside the EU, you would have to comply with copyright law proper, and those would be stricter standards under, for example, that kind of judgment by the Hamburg Regional Court. And that probably wouldn't be good news. Now, that would be a competitive disadvantage for European businesses. Of course, the jury is still out of that. One of the problems we have is legal uncertainty, and there's further case law in the EU. There's a couple of cases from the Netherlands, from Hungary, none of them really concerning AI training. The Hamburg case really concerned AI training. Those concerned more traditional crawling activities, and those cases also focused on robots text. And most importantly, meanwhile, there is also a recent reference from Hungary for a preliminary ruling by a Budapest court to the CGU, and that will allow the CGU to clarify some of the copyright rules on training and reproductions, on training and the TDM exception, and that is really good news. Also, a take-home message of my talk today for certain specific needs of the smaller member states of the European Union. really take the occasion and refer cases to the CGU. It happens a lot from the Baltic countries. We have a couple of references in the data protection field from the Baltic countries. We have recently a couple of references from Hungary, and that actually, given the degree of regulation in the European statutes, is one of the most efficient ways of shaping European law. Just refer cases to the CGU. It's mostly the Germans at the moment referring cases to the CGU, and that is a means of shaping European law, because those reference decisions will have certain reasons with them. They will have an attitude of the national courts going with them. They give the national governments the occasion to give an opinion on what should be decided. So referring cases to the CGU is very important to shape European law, given the high degree of regulation we have on the statutory level. There is another high-profile case, German Music Collecting Society GEMA suing Suno and Udio in the musical field before the Munich Regional Court, and that might also go up to the CGU if this went according to our wishes. Those two cases would be consolidated into one case before the CGU. But let's see, there is an oral hearing in that GEMA case in the Munich Regional Court in September this year, and then we will see what happens. The bottom line is, the EU has taken a bold step forward in regulating AI training. We have statutory provisions, but those statutory provisions for the moment being require a lot of specification of open-ended standards. They require a lot of application in the technological field, and there is legal uncertainty with regards to the implementation of opt-out. So it is a mixed picture. But let's not be too scared by this, because actually the picture is as mixed under a worldwide perspective. And whereas Lucy will discuss those international aspects on how to localize the use acts, on how to apply this globally, I would like to give you a very, very brief and very high-level comparative law overview on what the other jurisdictions worldwide do with regards to AI training. And make no mistake, whatever people tell you, the picture isn't so much more liberal and so much more easier in the US. In the US, on AI training, more than 50 cases are pending in a large number of both federal and state courts. And the basic question here is whether AI training is fair use. Does the source of the material matter? The Bart's Court, Northern District of California, very much a tech-specific court, says, well, if you use illegal material, fair use won't apply. Training is illegal. The Cadre Court, same court, Northern District of California, different judge, says, well, it doesn't matter, will still be fair use. Both cases probably going to the Court of Appeals for the Ninth Circuit, a very much tech-specialized court, a lot of legal uncertainty. Is the case law on intermediate copying being fair use as long as there is a highly transformative output? Will that be applicable? No one knows for the moment being. Will general market dilution, that is the fact that AI output might devaluate the creations made by artists generally, exclude fair use? The Copyright Office very much was of the opinion that this excludes fair use, but meanwhile the head of the Copyright Office, the Registrar for Copyright, Shira Perlmutter, has been fired by the Trump administration. So we don't know, is it still an applicable report they have given in February this year? The American Law Institute has published a very tech-friendly restatement of copyright, or is about to publish it, but several prominent law professors in May 2025 have stepped down from the project and the preparatory commission for that restatement of copyright law. And in the most high-profile cases, that is a Delaware District Court case in Thomson Reuters and West, that concerned the Westlaw database and an infringer who trained on that database, The Bart's and Entropic and the Kadri and Meta case, the latter concerning Meta's training activities, the former concerning Entropic's training activities, both using copyrighted works of literature, the outcomes are totally uncertain. Bart's actually says, well, all this was illegal because you partly used illegal sources. It is a class action that might lead to damages in the billions if this was held being the law by the Ninth Circuit. No one knows yet. On the other hand, they said that general market dilution theory doesn't apply. On the legal side, that would be good news because then training might be fair use. Kadri and Meta just the other way around. On the facts, they said it's legal. But on the legal question of whether the general market dilution might exclude fair use, they said, oh yes, well, it might well exclude fair use. Just show us that general market dilution. And that was one of the most prominent tech lawyers in the US, but he didn't show that market harm. And they said, why didn't you show that market harm? If you had shown that, we might have actually decided that this is copyright infringement. I don't want to bother you with the details of that. I've actually published papers on this and I will have them in the end. The bottom line is there is a lot of legal uncertainty in the US as well for the moment being. So what are possible answers? The juries are still out in US law. Is there possibilities for collective licensing? Collecting societies coming into play, fostering collective innovation by basically granting collective licenses for a large number of right holders at the same time, basically coming down to some kind of, we're just stream Claudio, right? To some kind of tech businesses tax, then distributing this to the artists, not prohibiting, but just fairly remunerating the artists. Well, I don't think this will happen in the US because they don't have the institutional factors in place for that kind of collective licensing. It might have happened in the past with regards to the Google Library project, because a class action in the end of the day might lead to collective licensing, but typically there aren't strong collecting societies in the US. Rather, in the US, certain large individual right holders, the music majors, for example, just now negotiating with Suno and Udio, the Authors Guild, they might negotiate individual licenses. That might work, but would that be good news for the individual artists? I don't know. It would probably just be big business negotiating with each others. So licensing will happen to a certain extent in the US, but it will be individual licenses, big tech negotiating with big right holders. Probably not so good news, probably not very legally certain either. What is the situation in Asia? Japan, very liberal. Singapore, very liberal. They are really opening themselves up for new tech models. China, I'm not so sure. There is no exception for AI training, but it is tolerated in practice. Nonetheless, China is not taking a regulatory liberal stance on the AI. Rather, they try to exert a certain level of legal control, and that level of legal control might be bad news for innovation and businesses. So I'm not so sure whether China is really moving so fast and so dynamic. Actually, they are discussing data rights, they are discussing new patent rights, they are discussing new unfair competition tools. They're discussing a lot of legal regulation, and they're discussing a rather high level of control of those new technologies. So with regards to China, I am really neither sure whether this is a regulatory model nor whether they will be so successful in the long run. But when you look into Japan, when you look into a small country such as Singapore, they are moving fastly. They are moving very liberally. Those guys are interesting. So, let me end this because time is running out and I'm very well aware of that. The AI outputs might also be a problem. Of course, there will all kinds of infringing outputs, but that is just another side of the story I told you about anyway. It happens more often than can be expected. Again, legal uncertainty will follow from this. All that is pretty much just the other side of the training coin. Here is my bottom line and summary of the presentation. In the end of the day, all jurisdictions worldwide will have the choice between three different kinds of approaches. A maximum kind of approach, no training without licenses in place. This won't work. It would prevent innovation from happening. It's not what is discussed policy-wise, will not work, will not happen. The other possibility, and that is a real possibility, it might happen, is a minimum approach. Just liberalize it, that the businesses do training, have no copyright control, have no licenses at all. This is what Japan is trying to do, and just now a policy discussion is bubbling up. Right holders are waking up. There is discussion whether those exceptions should be limited. It's what Singapore tries to do. A very small member state moving fast might be able to do that, but also probably it won't happen. What will happen is all jurisdictions worldwide will discuss and in the end of the day specify possible middle ways. And in that regard, I think the news for the EU isn't so bad, because whereas the US now have that kind of litigation going on, will have some kind of individual licensing, big tech negotiating with big right holders and whatnot. In the end of the day, the artists not seeing much of the money coming out of this. The EU at least has some rules in place already. And if those rules in the end of the day led to some kind of an exception to copyright for AI training, either based on the statute, the opt-out being implemented in a liberal, a flexible way, and then having remuneration, either being based on collective licensing by collective management organizations, that is, copyright collecting societies, and if then the European offer would be legal certainty, against a small but significant payment by the tech companies and with exception in place for the SMEs, then this might be an attractive offer. Because then the European sales pitch would be, we offer legal certainty instead of being faced with a multifaceted litigation in 50 states of a federal state. Then this might indeed be an attractive sales pitch. But of course, there is the international dimension. If you are training outside the EU, you aren't covered by EU copyright in the first place. We will discuss that. So we will need conflict of law rules for the AI. We will have to answer the question to what extent the AI Act applies extraterritorially and to what extent copyright law applies extraterritorially. And that is actually what Lucy Antoine will discuss immediately. Thank you very much for your attention. And I'll be happy to answer any questions.
Thank you, Professor Leisner, for such a overarching presentation with a lot of the questions that will be discussed in the future. I was trying to put my heart in the heart of the investors that are putting money in these companies producing the models, whether they will have something at the end after we start to have some certainty on what is going to happen, but also thinking on technological precedents to AI that may give us some clues how we are going to move in the future. And some compares AI to the printing press, right? And when books started to be print and print and print, where the copyright was the main issue, or we move the technology forward and then we saw how we regulate it after. But now, as Professor already said, I'm going to invite Dr. Lucy Antoine to the stage. She is a postdoctoral researcher at LMU Munich, holds a PhD in LMU and with a doctoral thesis on copyrights and computer programs, Her research interests are intellectual property law with major focus on copyright and data law, including protection of personal data. The presentation will be focused on the European Union Acts, looking as well to the 4 types of risks that are there, the extraterritoriality that has been mentioned a couple of times as well, and also how it plays with other of the major regulations that we have in the European Union. And so there will be a lot of practical insights as well. Dr. Antron, please, floor.
Thank you very much. It's great to be here. And yeah, I'm building now upon what Matthias already painted. First, the bigger picture, AI in Europe, with a particular focus, so to say, on the broader regulatory framework beyond the AI Act, but also diving a little bit deeper into the AI Act and discussing some more aspects beyond this Article 53 that has that contains this copyright-related obligations for general purpose AI providers. So I would like to proceed basically in 3 steps. And as we are here today for a kind of interdisciplinary perspective, I will try to focus a little bit on the perspective, on the view of businesses. What are the important obligations, but also what are possible possibilities resulting from the EU regulatory framework regarding AI. And in first step, looking at this regulatory framework, I would like also to raise your awareness beyond the AI Act and the GDPR and show you that there is even a little bit more around there. But as also Matthias mentioned with regard to copyright on the one hand, but also the AI Act and also the GDPR, there is flexibility. And there is a certain margin for interpreting the respective provisions. And I will show you one recent example relating to this meta training with personal data, with content made publicly available by meta users on Facebook and Instagram, which also has been subject to recent judgment in Germany. And lastly, I will then, so to say, focus on possible opportunities for SMEs, for businesses, for startups, and also, looking a little bit beyond the mere regulatory angle, taking into account recent EU activities in this regard. So, as I said before, it is quite clear that the AI Act is important and that the GDPR is important wherever personal data is at stake, being at the training level or being at the output level. And that is, as all of you know, since 2018, since we have the GDPR, nearly everything is personal data. Because personal data is every information that can be traced back to a natural person. And this is even the case if, so to say, the information that allows to trace back the information is not only in the hand of one person, but another actor has, so to say, the information to establish the link to the data subject. But there is more. There is the Digital Markets Act containing certain competition law-alike obligations for gatekeepers that offer so-called core platform services. Cloud services, search engines, marketplaces. And it is often overlooked that this DMA is particularly interesting for AI regulation. Why? Many of those gatekeepers are actually also providing AI services. However, at the same time, the DMA does not contain a particular, not a specific provision or definition regarding AI service providers. So it's still quite open under which, so to say, core service the provision of AI models or system might to be subsumed. Then there is also the not very known P2B regulation, the platform to business regulation, which establishes transparency rules in the relation between platform services and business services. You might think, why is this relevant for AI? If AI services offer ranking of products, of services, and so on, they, beyond the DMA, might also be subject to the additional transparency duties as contained in this P2B regulation. Then we see certain cyber security related acts, like the NIS2 directive and the Cyber Resilience Act. Also here, it's quite logical that AI should meet basic cybersecurity standards. But for instance, the Cyber Resilience Act contains obligations how smart products, tangible objects, should be designed, but that also relates to so-called software products. And every AI model or AI system that you market obviously also qualifies as a software product. And therefore also the recently updated Product Liability Directive, now explicitly entailing software as a product, covers a strict liability for manufacturers, for providers of AI products or smart products that contain certain AI services or functions in it. But let's take a closer look after this rather general overview to the AI Act and the GDPR. I always like to bring this little picture that the European Commission at the very beginning, when publishing the AI Act, used on LinkedIn, because it describes very well the basic idea of the AI Act. It says, if AI were a car, the AI Act would be your seatbelt. What does this mean? On the one hand, it shows the idea of the European Commission that the AI Act should safeguard the security of European citizens. However, at the same time, it's also nice to draw a parallel to this product safety law character of the AI Act. Because you're not allowed to market a car in the European Union that does not have has seatbelts. So neither you are allowed to market an AI model or system falling into the scope of the AI Act that does not fulfill the requirements as set forth in the AI Act. So this is where the AI Act starts from. And it's quite convincing to use this parallel approach. However, as we heard already, regarding, for instance, those copyright-related obligations for general purpose AI providers, this does not fit quite well into the established IP framework. Just, for instance, because Article 53 and its corresponding recitals also wants to extend to a certain extent to activities that take part outside the European Union. So what is the AI Act about? We already heard about certain prohibited AI practices which are qualified to have an unacceptable risk. Those are practices such as social scoring, exploiting the vulnerabilities of certain groups, of societies, and so on. I would say that is, convincing, and we can find a rather broad consensus for those prohibited practices. Then, in the core part of the AI Act, it contains in its Chapter 3 obligations for so-called high-risk AI systems. We'll dive into those high-risk systems in a minute. What is important to stress here? The AI Act, looking at this little overview, does not cover all AI models and AI systems. When the European Commission, for the first time, presented this proposal, they were estimating that more or less 10 to 15% of all AI systems and services would qualify as high risk. So there is a lot still out that does not fall under one of these categories. This is a little bit, this has changed a bit since within the legislative process. Those obligations for providers of general purpose AI models have been introduced, and to a certain extent, those obligations do not very well fit into the risk-based approach of the AI Act, because, as you see, it follows just a different regulatory model. The basic explanation for it was the rise of ChatGPT that has been released during the legislative process, and there was the feeling there should be rules on general purpose AI models within the AI Act. Matthias already talked about those transparency obligations, for instance, regarding AI-based chatbots and, most importantly, deepfakes. Also here, quite convincing and, so to say, a good idea. So what is also important to mention, we haven't discussed that yet, so to say, on the hard facts, is that those provisions for for providers of general purpose AI models are already fully applicable since 2nd August of this year. So all these obligations contained in Article 53 relating to the policy with regard to identifying opt-outs pursuant to the DSM directive, and also the obligations set forth for providers of so-called general purpose AI models with systemic risks, already have to be fulfilled. There is an exception for models that already have been placed on the market before August 2025, and they will still have 2 more years and will have to fulfill by 2027 those obligations. All the other provisions, in particular those relating to high-risk AI, will apply from next August on. So 1 year is left for adopting and, so to say, safeguarding compliance with those rules. I just very briefly want to take you through a journey through what is high risk and what are the obligations for the different actors. Because what I want to stress, it's not only the providers of an AI model or an AI system, but it's also what we might untechnically call the user, who uses an AI system within a business, within a company, might have certain obligations resulting from the AI Act. An AI system, so to say, the AI application, qualifies as high risk in 2 cases. First, the AI system is a safety component or a product, or qualifies as a product itself, that is already subject to existing European product safety law regulation. Those respective acts are contained in Annex 1 of the AI Act. One example is, for instance, an AI-based medical software used in a hospital or in comparable cases. The second, even more important case group is where the AI system is used for a high-risk use case. So here, with regard to this case group, Annex 3 of the AI Act gives a list of possible use cases which qualify as high risk. And this is, for instance, the access to essential private and public services, but also education, migration, or employment, and also what we heard already in the morning, law enforcement is one of, so to say, the sensitive areas. If an AI system now qualifies as a high-risk AI, being subject to those rules as foreseen in the AI Act, as I said before, we have different actors here. We have the provider, that is naturally the person, natural or legal person, developing and marketing such an AI system. Those providers basically have to guarantee that the AI system meets all the requirements before bringing it to the European market. Importers and distributors of AI systems have to check whether the provider for which they act has complied with all the requirements as set forth in the AI Act in order not to be liable themselves. So also importer and distributor, as already known from product safety law in general, do play an important role and have to be very careful in order to exclude their own liability. And then from a business perspective, that is the most interesting one. There is the so-called deployer side. And the deployer is a person using an AI system under its authority. The only exception is personal use for non-professional activities. And this is a very low threshold. So many businesses using an AI system, for instance, in the health sector, that very easily qualifies as high risk, themselves have to fulfill certain obligations which are foreseen in the AI Act. We won't go through it in all detail, just a short summary of what providers have to do before bringing an AI, high-risk AI system to the European market. They have to assess the risk, they have to document, they have to follow more or less the principle of transparency by design, and they are also obliged to provide sufficient information in the downstream value chain, because only such information on the training, on the functioning, also, for instance, on the aspect of human oversight, allows along the value chain to be able to comply with, for instance, the duties who are on the deployer side. The provider also has to guarantee that the system is registered, that the conformity assessment is carried out, and so on. And this is also on the distributor and on the importer to be evaluated and checked before, so to say, marketing a respective system. And here comes the deployer side. The deployer, for instance, a business, has to safeguard that the system is only used in accordance with its instructions. But more importantly, it also has to implement an appropriate human oversight mechanism. And also here we see there is quite a huge uncertainty what that would mean. Is it okay to have, so to say, a qualified person within in a company saying, you are the data protection officer and at the same time have the responsibility to train everyone and to check whether all those obligations are in place? Or is it really human oversight in a strict sense? Let's see. And what is also important, deployers themselves might be obliged to carry out a fundamental rights impact assessment for high-risk AI systems. So they themselves have to assess whether and to which extent an AI system might bring certain danger for fundamental rights of the persons who are subject to those high-risk AI systems. So that is the basic framework of the AI Act, and as I said, deployer side of a very is the point that is very often underestimated, even when you're not, so to say, the mere provider of a model or a system. Let's dive quickly into the protection of personal data and so the impact of the GDPR on AI training and AI output. Also here, comparable to what we heard from Matthias regarding to copyright, we have certain different phases and also different related legal questions. That is first the training or also fine-tuning on the basis of personal data. We have the question whether a trained model still contains personal data or can be qualified as anonymous. This is important because this has a major impact on the question whether the deployer or the user might be liable for unlawful training with personal data that is not in line with the GDPR. And regarding this point, the legal evaluation might be slightly different from copyright because the notion of personal data, as I said before, is very broad and even covers data that only can be traced back to a natural person with the help of someone else or the information that comes from wherever. Regarding AI training as such, the crucial question is, what is the legal basis? And the big discussion that we already knew from times before AI training is whether consent or legitimate interest, so to say, are, or which of those two is the better one or the one that can be achieved more or less easily and at the same time provides a rather high degree of legal certainty. Consent would provide a high degree of legal certainty. Legitimate interest is flexible, but provides a rather low degree of legal certainty. Why? Because whether a legitimate interest exists is evaluated ex post by the respective authorities or courts. I want to point you to the European Data Protection Board's opinion of the end of 2024, which is interesting because it once again stresses a very basic concept of the GDPR, recalling that there is no hierarchy between the legal bases provided by the GDPR, meaning that, for instance, Meta is not in any case required to obtain a consent as far as it is able to identify a sufficient legitimate interest for its processing activities. And interestingly, this European Data Protection Board's opinion goes back to the Meter case, and so to say, was initiated by the Irish Data Protection Authority's proceedings against Meter. That in 2024 started, and in a first step, so to say, stopped Meter from using content of their users for AI training. However, in April and May, Meter and the Irish Data Protection Authority were able, so to say, to find a consensus on the requirements under which Meter can use content of their users for training. And as part of the intent to stop this activity, a German consumer organization tried to stop Meter's training before the Higher Regional Court of Cologne by means of a preliminary injunction. And what is interesting is the argumentation of the court. It's only a preliminary injunction, so it's not, so to say, set in stone, but it provides certain interesting insights. First, the court denies that Article 5.2 of the Digital Markets Act that prohibits cross-use of personal data from different services would be infringed when Meter uses personal data of its users, with the argument that using personal data for AI training purposes is not a mean of bringing together data from different services. It's just using the data for, so to say, inferring information. And what is also interesting, the court held that indeed Meter has a legitimate interest in the sense of Article 6(1)(f) of the GDPR to use publicly available content of their users on Facebook and Meter, basically with the very, as I find, convincing argument, the users are able to object the use, and users themselves have made the contents publicly available, and they are easily able to restrict the availability of the content for the entire internet. So what I would like to stress in this regard is that indeed also the GDPR has certain flexibility, and there is the leeway for interpreting and taking into account the entire picture that we see. On the question whether AI models contain personal data, we might discuss that further in our general discussion. It depends a little bit on the particular circumstances, so we won't dive into this one deeper. But as I said, it's mainly important for the question of accountability and also for the qualification as a controller or joint controller. If the AI system puts out personal data, that is obviously also an infringement. However, comparably to copyright law, there it's rather easy, so to say, to establish the liability based on the existing or along the existing lines regarding joint controllership and accountability. We'll skip the Digital Markets Act, and I just, so to say, I know also my time is running. I will now come, so to say, to my conclusion and also my perspectives. There might also be possibilities within this entire framework. Within the AI Act, we already heard about the sandboxes, and if I understood correctly, we will still hear more about the implementation in the afternoon. But what is also interesting, for instance, with regard to personal data, there are new legal bases beyond the GDPR for the use of personal data in very specific AI-related cases. For instance, in the AI Act, but also with regard to the use of health data in the European Health Data Space Regulation. The Digital Markets Act, facing gatekeepers and their strong market and data power. The provisions on interoperability, so access to services, and also, so to say, accessibility to APIs and so on, might be interesting. The same holds true with regard to the data access rights contained in the Digital Markets Act. Regarding data that might be useful in order to set up a training data set, also the AI Act has to be stressed, as also Matthias already did. Why? It contains the possibility to get access to IoT data in a very broad range and also on an industrial level. And talking about those new opportunities, I also wanted to point you to the AI Continent Action Plan. That is once again a communication from the European Commission that is a little bit cloudy. At the same time, at the core, it touches upon many of those aspects that we already have talked about. We'll see whether it will really, so to say, get down to the very sticky parts. But it aims at simplifying rules on the one hand, and it's also aiming at facilitating the availability of data for training purposes. So apart from, so to say, certain, again, regulatory intervention ideas, and in particular the idea to simplify certain parts, even documentation obligations from the GDPR for SMEs, it also aims at fostering private investment into the development of AI factories and so-called AI gigafactories. And that might be a nice place to end, because today to a certain extent, we're always posing the question, is regulation stifling innovation? And yes, to a certain extent, that might be the case. But reading, for instance, Anu Bradford's book, Digital Empires, you know Anne Bradford because she wrote the seminal paper on the Brussels effect that we already mentioned various times today. She said, Europe, your problem is not only the regulation, but your problem is also, first, the mindset. Failing here is an issue. If you fail once, no one will ever give you money again. And second, the problem is also the availability of venture capital. And that might be true, that might be convincing or not. The point that I want to make is we should look at the bigger picture. And this AI Continent Action Plan, let's see whether it can have certain impact. I'm quite hesitant, but it takes up some of these ideas, trying, for instance, to incentivize even private investment, safeguarding this with an underlying regulatory framework, so to say, as a measure to bolster this idea of safeguarding innovation in line with European fundamental rights and democratic values. Thank you.
Thank you, Lucy, for this very informative presentation. I think we have a lot of details to start working on. And now, last but not least, I will invite Dr. Dana Beldiman. Dana teaches at Bucerius Law School in Hamburg, Germany, and the University of California Law San Francisco in the United States. She has founded the Center for Transnational Intellectual Property, Media and Technology Law, and Policy as Bucerius Law School in 2012 and has served as director since. She also has lectured at numerous institutions, including this house, in the Riga Graduate School of Law, Humboldt University, Chinese Academy of Social Sciences, Santa Clara University. Is author of several books and numerous articles and acts as expert of WIPO. And her primary research and teaching interest lies in various aspects of comparative intellectual property law, trademark and design, as well as technology law. The topic will be on collective innovation open source, and we were discussing before the event that probably in this country we don't have the possibility to create base models, but maybe this is the place where we can be part of it. And understanding the current regulatory framework or the future or the potential regulatory frameworks, it can give to our industry a much clearer picture of where we can go. Dr. Beldiman, welcome.
Thank you, Claudio. Dear guests, thank you for being here. It's an honor to speak here. I also want to thank the organizers, RBS for their fantastic support, and RGSL for hosting us. So let's see. I will talk, we will switch gears a little bit. Let's see how this works. Yes. Quick question. How many of you are familiar with open source licensing and how it works? Okay, yes, indeed, some. Thank you so much. All right. So we are moving more into the law that supports business operations and business opportunities. And so what is open source? It's a distributed collaborative form of innovation. And by analogy, let's think Wikipedia. We're all familiar with Wikipedia, right? Open source has the same mechanism of creation and the same mechanism of distribution. It's created by many people collectively. It's distributed to many people collectively for their use. Now, the counterpart, of course, is the alternative is proprietary innovation, copyrights, patents, and so on. Both open source and proprietary innovations are methods of innovation which produce knowledge. They're producers, they're knowledge producing mechanisms. Proprietary innovation focuses more on a single inventor or a small number of inventors. It thinks about monetization towards incentive to create. Open source, conversely, is collective innovation, and it focuses on the involvement and contribution of the community. But both, as we said before, Professor Leistner mentioned that, they both rely on IP. IP is essential, and even though you might think that open source has nothing to do with IP, that is not the case. It only functions because of IP, and I'll explain to you how. So the only question is how is the IP organized, and what is the immediate economic and social goal of the two strategies. So, but otherwise, they function symbiotically, so you can use open source and proprietary innovation together. Very briefly, okay, and so this is the question that that we will discuss today is what role will open source, which was created in the software environment in 1990, can it survive in the AI space, and how will it survive, and what role will it play? So very briefly, what we'll talk about, number one, the legal aspects about open source. And I don't want to bore you with a lot of legal technicalities, but give me like 2 slides to explain to you how it really works. And then we will go on to the functional and business aspects. Can it survive in the AI space? What's the functional part and what's the business perspective? And since we're rather pressed for time, I will compress this as much as possible, not wanting to bore you. I know Claudia will be very happy. Look, he's smiling. So here, let's look at how open source software works in the software field. And here I have a little bit of drawing that will help you. So again, think Wikipedia. Yes, we have a project initiator. They own the copyright, and they create or transfer by open source license this license to the community at large. Anyone who wants to contribute, who has something to say on Wikipedia, or has to add to the source code of open source licensing, can do that. The outcome is the initiator project, which is the open source, plus the community additions, and the product is openly and freely available to the world. Right. What does this open source license say? It's fairly simple. It's a legal mechanism, yes. And what it says is the initiator holds the copyright in the source code, and that's the IP part of this. And without the copyright, this whole structure is not possible. And secondly, the initiator releases this work creation to the community under the following conditions. Number one, they will not enforce copyright. So in other words, members of the community can study, modify, distribute, etc., whatever is in that work without being sued by the initiator. Number two, it's royalty free. So the community does not have to pay. Right. So this is a great mechanism. And then you will ask, well, why do all these members of the community, why will they work and participate and contribute to the work? And here we have why. So there's an enormous amount of literature on the motivations why they do it. Generally, their personal motivations. They need a challenge. They need to tinker, to play, and so on. They need satisfaction of finding solutions, etc., gained experience. But the key are the 2 elements at the bottom. What is their material contribution? Do they? Okay, they don't pay for the open source work. Do they pay otherwise? Do they have to contribute? And the answer is minimal, because they will contribute in an area of their expertise, something they already know, and they look at the source, the open source code, and say, I can improve this. Takes them a few minutes. Number one, where do they do that? They do it typically at night, at home, on their personal laptop. So there is practically no contribution by the material contribution by the contributors. That's why they do it. Okay, and then the last question is, all right, how does anyone make money? Because we're here talking about business and opportunities. Does anyone make money in this scenario? Okay, and so let's go on to the next slide. There are, in fact, 2 flavors of the open source license. One is what's called the reciprocal license, and that means that the modifications made by community members cannot be commercialized. In other words, they have to be passed on based on licenses, just like the original one, an open license. They will forever be open like Wikipedia. We cannot appropriate a Wikipedia and declare it's our copyright. Right. On the other hand, we have, and here's where the misconception arises, there's no profit. Indeed, there is no profit in the reciprocal license. But we have the permissive license that was created at some point after open source software was created by some people who had a very practical orientation. And that says that any member of the community can take the open the source code that's open and develop on top, make modifications. Their modifications that can then be commercialized. And so that's very important. That's the basis of all the commercialization that goes on. Now, the open source, the source code remains open, but the modifications are the copyright of the community member who actually makes the modification. Okay, so that is the mechanism how open source works. Myth, there's no profit, because yes, you can make profit. And myth, it is totally in a separate world from proprietary innovation. Yes, they can work together. That was the software world. Now let's move to the AI world. How do we move? Okay, all right. So here you have the high-level view of the LLM model. And basically, we have an initiator who would like to open source license this LLM to, in this case, the public. I will get an example in a moment. In order to have a license, you have to, the proprietor or the initiator needs to have a copyright or an IP right in whatever they license. Now let's look at the artifacts of the LLM here, and we'll focus on the trained model. And the question is there an IP right in the trained model? And again, there has been lots of literature on this topic. I will not go into this, but let's look at what is the trained model. The trained model, of course, it's important because it's the brain of the LLM. But what it is, it's a process. It's a set of instructions. It's, a mathematical model just consists of parameters and weights and biases. All right. Is that copyrightable? Okay, here the opinions are split, but I think the prevailing view is that it is not copyrightable. And if you disagree, we can go in the question and answers on that topic. And under US law, we have 3 good reasons, which I will recite without. Number 1, there's no creative expression in the trained model. It is functional, which is excluded from copyright protection. Maybe most importantly, it is not a human creation. So therefore, we say, all right, trained model is not protectable. What happens to the license? Okay, if the license is if the copyright does not exist, what does the initiator license? Is there a license? Is it enforceable? Probably most people will say no, but again, opinions are split, and we will not know until the highest court has ruled. But certainly what is certain is there is uncertainty. We don't know. And then, of course, the question arises, what will happen to the OS, to the open source initiators? Will they all flee into the proprietary world? Will they protect their works by other things, trade secret and so on? And in that case, open source disappears. And the theory is not, and actually the practice, the numbers will show that. Here you have a page from Hugging Face. Hugging Face is the prime platform where open source artifacts are stored. And if you look at the curve from July last year, July this year, it has doubled. So basically, there is no dearth of people doing open source in the AI space. Okay, now how do we explain that? And it's actually quite easy. Why? Because this OS, or distributed collaboration, is a powerful knowledge production mechanism on its own, and it's essential to any effective innovation ecosystem. All right, Why is that? From the functional perspective, so it has this, open source has this intrinsic innovation-oriented features. They are, number one, it's a collective, collaborative innovation, right? Two brains are better than one, more than two brains are even better, and so on. The community works, and therefore we get a better product. Contributor motivation. We saw that people essentially work at no cost. But that opens up this field to many people to participate. So there is higher education, higher technological education. There's a democratizing effect of this, of the open source. And then third, we talked about the permissive license. It's very easy to integrate proprietary and open source project also in the OI space. Then business perspective, obviously there's complementarity, allows strategic positioning. And I'll give you an example, the next slide, how you strategically position open source and proprietary IP for benefit. And then finally, many people think that open source is faster, better, cheaper, etc. And it's ethically preferable because it's not made by big tech. Okay, here's to the example. You all know about Meta. Meta has issued its LLM called Llama. Here's its license agreement in 23 under what's called a community license agreement. Okay, let's assume the following scenario. So we have an LLM that is there, that is very powerful right now. It's the most powerful open source LLM. We have a developer. We name him Dev the developer. Dev the developer wants to develop, based on Llama, wants to develop an application, and here I love this application. It's the meeting assistant. I don't know if you've had any meeting assistants, but there's an AI sitting in your meeting, and you conduct your meeting, and out they come with a summary of what everyone says, and with a summary, and so on. It's wonderful. Anyway, it's an AI meeting assistant. So Dev uses the LLM Llama to build his meeting assistant on top, powered by Meta, right? Who benefits? Everyone benefits. Number one, Dev benefits because he can achieve this very capable product with very little time and effort, because Meta has already made the effort and built the LLM. And that's the beauty of AI and open source. The fact that Meta has released this gives everyone the possibility to build on top. Now, there's some work to do for Dev, but it's comparatively, it's very beneficial for him. But to whom is it most beneficial is for Meta. Surprise, surprise, because you wonder why they invested, I don't know, 100 million or way more into this LLM. Why do they open source it? Because they get no profit from there. But do they actually? So what do they get? They get contributors coming and improving their LLM, because Dev, in the process of building his application, will improve the LLM, will fix bugs, etc. So they attract talent. They heighten the credibility. The more contributors they have, the better Meta looks. There's a reputation, because they require Dev to put on his product powered by Meta, so everyone knows that every contributor has worked with Meta. And interestingly enough, the last thing is, there is a good chance that that Llama will become the de facto standard in LLMs. Why? Because they attract so many contributors who all are working on it, investing time, building on it, etc., etc. which is on the side, an interesting competition issue in the future, except now there are several other open source LLMs. Okay, so that was the example. Very briefly, I will give you two other examples of use, and I will cut this very short and then give you my conclusion. So basically, we're built on the social shoulders of giants. But here we have one example, GitLab. Don't confuse with GitHub. GitLab, basically, it's a Ukrainian Dutch company. It's a unicorn. It's very impressive. They started out basically from nothing, building a repository inside of GitHub. And what did they do? They leveraged the community that's in GitHub to work on their repository. Now they're one of the leading repositories, of artificial intelligence. Okay, next example is weights and biases. Again, starting from nothing. They leveraged existing frameworks, AI frameworks, all the tools that you see there. What they did is they created, if you will, some glue. So in other words, you have, in a one-stop shop, you have available all those tools. And so they are the default machine learning operation tool repository. So that is our business opportunities. Now to the conclusion. Basically, what we see is the symbiosis of AI and open source, right? Now, due to AI, we are on a level of very high technological level, especially compared to the software world. I mean, it's miles away. But we have these LLMs, we have these tools, and on these tools, one can build products with extraordinary capability because you use the LLM. All right, so you have a very high starting point, which you use either proprietary construction like Dev, because Dev was going to sell his meeting assistant, right? So you can do that. Or you can start from the bottom and use the tools that are available and build from there. But there are lots of opportunities available. And so all of this, I think, makes a wider availability for AI, wider availability for technological savvy people to participate at no great cost, and also for a democratization of the area, as well as an acceleration of the technological development. Thank you.
Thank you, Dana. And I will invite the three speakers, Lucy, Matthias, and Dana, to come and sit beside me. Feel quite alone here, lonely. And we're going to have a few minutes for Q&As. I know the refreshments are waiting. Everyone wants to be there at some times, and AI cannot transform the time. So, but let's go to business. Please, any question or comments? Don't be shy. We have some microphones, right? We have the first. Lina, do you have a microphone? We have the first one there. Yep.
Hello, Andre, my name. I guess my question goes to Lucy. How do you define publicly available data? Is it before the paywall or behind the paywall? So is it visible or is it invisible? Or distinguishing between even visible or invisible?
So it's interesting because under the GDPR, the notion is a little bit different than what we heard from copyright. So only in Article 9 of the GDPR relating to even sensitive categories of data, there we have an explicit exception for data that has been made publicly available by the data subject. And that is an important one, and that was also, so to say, one of the issues in this entire meta discussion, because it only, so to say, covers data that the data subject as such has published. So me as a user making a post or whatsoever. But what is a little bit more problematic in this regard is, for instance, photos or content that other parties have published about me. So that has not been personal data that I have been made available on my own. And here it becomes a little bit more difficult. At the end of the day, when we have, so to say, normal and not this particular sensitive data categories, all this goes into the balancing of interests under Article 6.1f. But, so to say, coming back to your initial question, paywall, yes or no, here we were talking about content that the user had really made available to everyone. For instance, also available by search engines and so on. So it's not this strict divide, paywall or not. It's more about, has the data subject as such made it available to the public, and is it available from this perspective?
Here is a compliment on the copyright side. First, a general remark. It will be very interesting in the future to compare all those different rules, data related on the one hand, personal data versus commercial data, and copyright and IP rights on the other. That concerns legally available, but that will also concern all kinds of liability issues where platform liability in IP law might well differ from data processing principles. So we always have those two standards. In copyright law, the news is essentially good. Legally available data is any publicly available data for crawling and the like. So even if, surprisingly, that was under a license and it was illegal effectively to crawl it, if it was publicly available on the internet, that will be regarded as legally accessible and that will be okay. Then if it's behind the paywall, that can be legally accessible once you have paid. But in the process of paying, of course, you will conclude some kind of end-user license. And then in that end-user license, crawling acts, training acts, and whatnot might be opted out and the like.
Thank you. Here we have questions. So I was thinking about the training process. And do you think it could be a practical issue to prove that actually the work has been used for the AI training? Or is this not a big issue in practice because you can't look into the AI model?
Well, yes, of course, that is a huge issue. First of all, on the legal side, of course, we have the new transparency duty under the AI Act. So on what material were those models trained? But as far as we can see, the AI office will specify this at a rather high level. Lucy will correct me if I'm wrong here. So they basically relate that to the discussion and practice concerning the data sheets and whatnot. So what you will get is rather high-level information on what the general input into that training model was. And you won't get any specific information on the actual specific work being used. Practically, if there was individual litigation, that would be an almost insurmountable barrier to any effective individual litigation. So your only possibility is basically, I think, two avenues to overcome that problem if you were a right holder. First, of course, you can try to provoke the model into hallucinating something which is very akin to your content. And that is what Gemma has done. Look into the Gemma cases. It's quite impressive. They have tried to actually put very specific examples from musical songs texts into this, and then the thing comes up with the same music. So you can still provoke this into hallucinations very akin to your works, and then you have proof. Second possibility is all those new instruments of collective licensing, such as, for example, extended collective licensing. And Gemma is planning to offer an extended collective license for training, and then that license will cover any relevant work anyway. And then with that kind of license, it will be very hard to argue you haven't trained on those works, because Gemma is basically saying, well, we have the entire global repertory for what you might have trained on, so what else might you have taken if it wasn't synthetic data and that doesn't effectively work? So it's either collective licensing that might overcome that problem in the future, or in individual cases, you will have to go the hard way and try to provoke this thing into a mistake.
Thank you. Yanis? Yeah. We have two more questions. And then
Hello, my name is Yanis. Devil's advocate question about the cross-border training of the AI engines, and I think especially with the proliferation of also dark actors. I think you mentioned kind of the more or less legitimate actors with understandable legal systems. But there are dark actors as well on the web. Thank you.
who wants to take that on the dark actors?
Well, first of all, extraterritoriality is a huge problem, even for the white actors. We've just seen the Getty case in the London High Court being negotiated, and whereas Getty continues to be a big case in the US, the London High Court has basically said, since the training was taking place in the US protection territory, and since it wasn't possible to provide proof of sufficient connecting factors to the EU territory, also the tech provider arguing trade secrets and whatnot, it wasn't possible to effectively continue the copyright litigation in the EU. The AI Act will extraterritorialize some of those standards, but at a rather high level. And in that regard, basically, we are proceduralizing the problem. So as long as you can prove that you have certain procedures in place, that will be okay. And then there is a real bad guys. And as to the real bad guys, I don't really see a possibility currently to get them, because you won't be able to enforce in those jurisdictions. And as for the users within the internal market, you will have all kinds of problems in getting the necessary information and so forth and so forth. But I'm happy for for learning anything more about that. It is an obvious problem.
We have time for a last question. Yes.
So firstly, I wanted to make a brief comment about the enforcement of the AI Act. So a question arose in my mind, how will it be enforced in the national states? I quickly researched the internet and found out that the national bodies that were responsible for data protection will also be responsible for enforcing the AI Act. And regarding this, I wanted to express my doubts that the Latvian body, the Data Inspection Agency, will be able to enforce this act, since it's been proven less than optimally effective in applying the data directive. And I wanted to ask a question to Mrs. Dana. Matthias told us that we have like one regulatory act in EU, but in United States, it's not regulated federally, but on a state level. So I wanted to ask if the regulation in the United States is homogeneous amongst all the states, or it differentiates. Thank you.
Maybe I would just comment on your first remark regarding the enforcement on a national level. Indeed, I would say in every member state, but I'm also happy to learn more from maybe your experience. This is one of the most intensely debated questions, and not only about the AI Act, but it also took place regarding all the other data and digital related acts. And indeed, as you mentioned, even though personal data is nearly involved everywhere in the AI Act, but also regarding the Data Act, for instance, we will see rather often a delegation to the National Data Protection Authority. But I'm also actually of your opinion that that is not the smartest version. And as far as I have seen, because going to the page of the European Commission, you can already click through those national authorities that have been already announced by different member states. And what you can see very, very often is many different authorities for the very different parts. So I think sometimes it's about 4, 5, 6 different authorities having the responsibility for parts, protection of, I don't know, fundamental rights and so on, consumer rights. And that, I'm not sure whether this is efficient either, right? Because if we have this distributed responsibility, so it's very different, and indeed it's one of the problems. Maybe the more or less good news is that at least the enforcement of the GPAI model providers obligations are centralized within the European Commission and the AI office, and I think that was a deliberate choice just because of this difficulties. And there we will see, hopefully, a more or less consistent enforcement strategy. Because also in general, data protection issues, we see this very diverse activities of the data protection authorities, talking about Ireland and so on. So indeed, I completely agree. Difficult, let's see what happens.
You're right, thanks. Are the laws homogeneous? Simply stated, no. Let me tell you just very briefly, I know this is our last question. So the legislative, the legislative system in the United States is such that it is very, very difficult to pass laws, unlike Europe. Is this good or bad? That remains to be debated, because we're not going to be flooded by laws, or at least so we hope. What happens is currently at the federal level, the Biden administration had passed an executive order that has been eliminated by the Trump administration. The Trump administration also wanted to impose a moratorium so the states do not legislate for a period of 10 years, which debatably was good or bad, but certainly it would have avoided any inconsistencies among the AI laws. As it stands now, there are about 400 state bills, not laws, bills pending in the various parliaments of the various states. They're totally inconsistent because one state has one priority, the other state has another priority. Very few have passed so far, and it is the hope that because of this general chaos, at some point, the federal authorities will rise to a point where they actually take action and legislate. What will come out of the legislation in this administration, or maybe the next, I don't know.
Maybe they take the EU Act as their benchmark opportunity. Good. Yeah, we don't have any more time there. I guess there were more questions from my side, but there will be opportunities in the network. Something that AI cannot do, but we can do. We can have mercy and have a little bit more of time for the refreshment. So we decided to change a little bit the agenda, and we are going to start at 1 p.m. Please enjoy the networking, use that opportunity and the refreshment, and also come back, okay? And there will be all the practical part. But please join me on a big applause to all the panelists.